Greetings, everybody. This this is Professor Hussein here again with Chapter 11, Buying and Selling Aircraft. It's important for us to really understand the rules and regulation behind aircraft purchase and or leasing. Most litigation over aircraft purchase arises because number one, buyer and seller did not come to clear agreement in all aspects of transaction, failed to properly document deals, particularly by aircraft's condition. Number two, buyers failed to commission an adequate pre-purchase inspection, title search before buying the aircraft. Number three, transaction was not properly documented, recorded with the FAA aircraft registry and new international registry. The laws of all the laws of all 50 states is now virtually identical in this area since all adopted Uniform Commercial Code (UCC) with few or no modification. UCC provides, however, that where federal statute provides system for recording documents of ownership and security interest in specific class of products, federal law prevails. This is the case where with aircraft under Federal Aviation Act of 1958 as amended. As we saw in Chapter 1, the aircraft registry in Oklahoma City maintains records showing entire history of ownership and legal interest in all aircraft registries. The sale of aircraft raises legal considerations not only for buyer and seller, but also for any lender who may be financing the purchase of buyer or any person of business that may already hold a security interest in the aircraft. If you're a buyer, you want to know, who am I really buying? What are the legal rights of aircraft? Turned out to be 11. Am I getting clear title for the aircraft, which is figure number 11-1 of this chapter. From the seller's point of view, there is also warranty law consideration in selling aircrafts. Sellers want to know the nature and extent of their legal liability if buyer later becomes unhappy with the aircraft, suffers condition lawyers refer to buyer's remorse. A lending institution, bank, or finance company financing a portion of the purchase for the buyer will be concerned with this basic question. How can we assure that we can get paid no matter what happens to the aircraft in the future? Number two, will we be exposed to being liable if aircraft is involved in an accident? Security interest is legal interest in an item or personal property that secures the payment of debt. A person or business may acquire security interest in an aircraft by loaning aircraft money to purchasers, obtaining security agreement signed by the purchaser by performing work or finishing goods or services to the aircraft. Mechanics and material men's lien or artisan liens, or by providing storage for aircraft. This is the form they normally use for registration of aircrafts. Perfection priority, except for aircraft engines covered by Cape Town Treaty discussed below. Filing the security agreements with FAA registry perfects a non-promissory security interest in an aircraft. If a lien holder who is not in possession of aircraft fails to record a security agreement of FAA aircraft's registry, a buyer is not otherwise aware of that security interest or faith purchase without notice, takes the clear title, and lien holder security interest is unenforceable. Release of liens. A prudent FBO, mechanic, or repair station will not release an aircraft after it has been worked on, stored, or fueled unless first paid by tax, credit card, cash, or certified funds. However, for some reason, business wishes or accommodates a long-term good customer claiming a temporary cash shortage, it may have the aircraft owner sign a promissory note for the amount due, secured by a security agreement, giving the creditor a security interest in the aircraft. These documents should be immediately filed with the aircraft FAA registry. Cape Town Treaty additional filing requirements effective 2006. Cape Town Treaty, formerly titled Cape Town Convention on International Interest in Mobile Equipment and its related protocols on matters specific to aircraft equipment, created a registry of mobile assets and added additional filing requirements for security interests and leases of aircrafts and components. International Registry, although physically located in Dublin, Ireland, operates entirely via secure transaction online, existing for all practical purposes only in cyberspace, and operating 24 hours a day, 7 days a week, 365 days a year. Interest in aircraft engines covered by treaty are perfected by filing, but also a two-step process requiring filing documentation first with FAA Aircraft Registry and then with International Registry. International Registry will not accept documents not filed with FAA. Priority for aircraft engines covered by treaty, whoever registers their interest with International Registry first has priority over other interests. Thus, for example, a lender that files a security agreement with FAA but fails to register with International Registry risks losing a priority to subsequent creditor that registers interest with International Registry, even if the subsequent creditors were aware of their prior lien. A prospective interest filed with International Registry is effective from the date of filing as long as transaction is later completed. Searching for International Registry, purchase of aircraft engines covered by treaty should search both aircraft registry and International Registry to determine existing ownership and other legal interests, if any, in the property. In order to perform search with International Registry, a person must obtain a priority search certificate from registry for the particular aircraft or engine that is subject of the inquiry. Title search companies routinely perform searches of both registries for their clients. Release of lien from International, as with perfection, filing releases is step 2 process requiring filing with both FAA and International Registry. A warranty statement or representation made by seller regarding year of manufacture, make and model, equipment condition title. These are not limited to permitted warranty you routinely expect to accompany a product you buy, but may also apply to pre-owned products you purchase if not given in writing. State law under UCC governs warranties. UCC provides for 2 categories of warranties: express warranties and implied warranties. Express warranties are not required to be expressed in writing, but may be created by oral representation by seller to the buyer during the course of negotiation for sale, and not to be any particular form. UCC has the following say about how express warranty is created. Express warranty by seller are created as follows: any affirmation of fact or promise made by seller to the buyer which relate to the goods and services becomes part of the basis of bargain, creates an express warranty that the goods shall conform to association of assignation of promise. Any description of goods by which part of the basis of bargain creates express warranty that goods shall conform to this description. An example of model by which made of part basis of bargain creates express warranty that the whole goods shall conform to the example. Not necessary for creation of express warranty that seller uses words such as warrant, guarantee, or have specific intention to make warranty, but information merely to the value of goods or statements perpetuating the merely seller's opinion recommendation of goods does not create warranty. Let's consider some example creation of express warranties in negotiation. The sale of general aviation light twin engine aircraft. The seller shows prospective buyer the engine logbooks, which indicates both engines have received major overhaul over 70 hours previously. This can be seen in both information of facts and description of goods that creates express warranty that engines have so recently benefited from an overhaul. If the buyer inquires about oil consumption of these engines, the seller states that just returned from a long cross-country trip in engine and it's not burned any oil. It may constitute information the fact creating express warranty as to low oil consumption. While FARs do not define airworthiness, NTSB and courts have held would to mean great deal more than simply that aircraft is capable of flight. To be worthy, an aircraft must be in its original proper altered in accordance with FAR's condition as verified by the logbooks. 11.4 state that it will fly is not a proof that aircraft is airworthy. To be deemed legally airworthy, aircraft must be in an original or properly altered condition as verified by logbooks, and maintenance records. Disclaimer warranty. UCC does, however, permit sellers to disclaim some warranties. Written express warranties cannot be disclaimed, but oral express warranties, implied warranties can be disclaimed. Such claimers are required to be written and conspicuous. All implied warranties can be disclaimed by the use of such approved expression as there is no warranty which extends beyond description of aircrafts on the face of this agreement, including but not limited to any implied warranty or merchandisability or fitness for a particular purpose. All aircraft is delivered except as with all faults or other luggage that is common understanding calls the buyer's attention to exclusion of warranties and makes it plain that there is no implied warranty. How to avoid litigation. As mentioned by at the beginning of this chapter, most litigation or aircraft purchase gone sour can be attributed to these facts. The buyer and seller did not come to a clear agreement on all aspects of transaction, failed to properly document the deal, particularly the aircraft condition. Number two, the buyer failed to commission an adequate pre-purchase inspection and title search before buying the aircraft. Number three, the transaction was not properly documented, recorded with FAA registry. Let's look more closely at these. Contract of sale to prevent necessity of litigation of what warranties were or not made or breached in sale. It is interest of both buyer and seller to have a written purchase contract clearly expressing the warranties agreed to or excluded from the deal, written by a lawyer, negotiated by between parties both represented by lawyers. Unless buying an aircraft known not to be airworthy for purpose of completion or rebuilding, buyer shall not agree to contracts containing warranty disclaimers like as is with all faults. Pre-purchase inspection is such a less expensive for prospective buyer to learn all that can be learned about condition of aircraft before purchasing it through a personal litigation claiming a breach of warranty later. Therefore, if you're considering purchasing an aircraft, you should hire an aircraft mechanic to perform pre-purchase inspection. The ideal person for job shall be someone you know and trust or enjoys excellent reputation, has no relationship with seller that might color his judgment. An airframe or a PowerPoint mechanic holding inspection authorization and has special experience with familiarity with particular make and model of aircraft shall be most desirable. Title search because aircraft can so quickly travel from state to state because the Congress saw the need to enable buyers and lending institutions quickly and simply determine who has the legal rights in an aircraft. FAA registry was established by FAA Analytical Center in Oklahoma City, Oklahoma. FAA Act, which created aircraft registry, requires that all documents reflecting ownership and security interest in civil aircraft to be filed there. Performing title search both aircraft registry and international registry shall reveal not only who owns an aircraft but also recorded security interests outstanding against the aircraft. One type of security interest is that title search may not reveal a promissory lien under law. State law, mechanic, FBO, repair station, or other business that has provided parts, labor, fuel, or shortage of aircraft is not required to release aircraft to the owner without being first paid. Where such business is holding aircraft awaiting payment, it is said to have a promissory lien on aircraft. Promissory liens are not required to be filed with FAA aircraft registry. Under law of most states, there is no documentation of promissory liens that one could file. Simply retaining possession of aircraft pending payments perfects a promissory lien. When purchasing an aircraft, it may be wise to purchase aircraft title insurance to protect against defects in title, legal rights that are not revealed by title search of records of FAA registry and international registry. Title insurance is most appropriate for corporate aircraft as it is usually too expensive for transport category aircraft and cost is difficult to justify the light single engine piston powered general aviation aircraft. Closing the sale. If you decide to purchase aircraft, it is good practice to have a formal closing of the deal. For such, you would be when purchasing a home with buyer, seller, then lending institution, lien holder, or a representative present. Distant lien owner often arrange for buyers' lending institution to serve as their escrow agent, sending lien releases to the institution to be recorded only after funds to pay off the lien has been forwarded to the lien holder. At the closing, buyer shall receive a single signed bill of sale from the seller. The FAA is form available free from most FAA officer website. If seller is corporation, check to certain that the bill of sale has been signed properly. Review these mandatory elements of proper corporate signature. If the signature is incomplete, aircraft registry will reject the document, refuse to re-register aircraft to its owner until the proper signature is obtained. CFR 47.3B prohibits you from operating aircraft that has not been registered to its owner. This one is just an example of aircraft bill of sale. The buyer shall receive lien releases signed by all lien holders who are executing these releases in exchange for what portion of sale proceeds covering the balance of debt still owed them. If the contract of sale prepared by lawyers is negotiated by lawyers for both parties, clearly expressing warranties and exclusion of warranties signed, agreed to has not been signed, it must be signed by both buyer and the seller at the closing. The contract of sale is not the same thing as the bill of sale. If you're financing purchase of aircraft, lender will require you to sign promissory note and security agreement giving the lender interest in aircraft to secure payment of the loan. Filing required. A bill of sale, lien releases, security agreement shall then be filed with FAA registry by mail through sometimes done in person, still expensive aircraft, along with registration application form signed by the new owner. None of these filing can be accomplished online. All must be submitted as hard copies with original signatures, according with FAA's Drug Enforcement Assistance Act. FAA will no longer accept aircraft registration application that is listed post office or mailbox as sole address. Street address or physical location is required. The pink copy of registration application, pink slip, must be kept in aircraft as temporary registration certificate. until FAA registry issues a new aircraft in new owners. It's prudent to assure that all these documents have been mailed before operating the aircraft. Also remember to ensure the liability and hull insurance on the aircraft has been bound and is effect before starting the engine. The pink slip is legally adequate as a temporary registration for flights within aircraft within the US, but international agreements require that you have permanent registration on board before crossing international borders. This one just shows you Department of Transportation's registration. Just let me get closer here. US Transportation Aircraft Registration Application. It gives you all the details, individual partnership, name of applicants, all the good stuff. An application of aircraft radio station license is newcomer's name must be filed with FCC in Harrisburg, Pennsylvania. If you intend to operate aircraft across any international but not for operation wholly within the US, most FAA offices also stock free copies of this form. If a 406 megahertz emergency locator transmitter is installed, there must be registered under National Oceanic Atmospheric NOAA's facility search and rescue efforts in the event of activation. Tax or registration. Purchase of aircraft shall have to pay either sales tax or use tax transaction purchase of state of residency. If the sales tax took place in the state, then the sales tax that applies to other states for goods also applies. However, if aircraft were purchased out of state, then brought into a purchaser's home state, a use tax applies instead of sales tax. Law in most cases provides that if purchase has paid sales tax on purchase in the state where the aircraft was purchased, the amount is credited against any use tax due in purchaser's home tax state. Summary. Clearly following the procedures described in this chapter, it shows that buyer clear title to the aircraft. Assures that both buyer and seller are quite clear on what legally enforceable promises have been made regarding aircraft and its condition. Coupled with techniques of naming the lender as a loss payee on the aircraft's hull coverage, insurance coverage, and obtaining lien holders' interest endorsement, breach of warranty endorsement on that policies discussed in Chapter 6. These procedures assure the aircraft the lender of payment of any balance in the loan, even if the aircraft is later destroyed in an accident along with its owner. This is it for chapter. This chapter. If you have questions, concerns, call me, email me, or text me. Thank you and have a great day.